Recording in progress. Recording stopped. Recording in progress.
Can you hear me now?
Yes, I can hear you.
I can hear you.
Okay, I could not hear you, colleagues. So good morning, and thank you very much for joining us. I need to get your surname correctly, the pronunciation of your surname, to our witness this morning. Can you do that for me? Maria is easy. I need to get it right because I'll be mentioning it all the time during the course of the hearing, and I wouldn't want to offend.
Rambauli.
Rambauli.
Yes.
Okay, I suspected so, but I needed to be sure. No, thank you very much, and good morning, colleagues. So, just by way of for the members and for the public, we were going to have two witnesses today. After Ms. Rambauri, we were going to have a witness whose face we were not going to show, Mr. X, as it were, Mr. X has expressed heightened concerns for his safety and asked to withdraw. So the committee will just have to decide how we move forward on that part of our work, because he had submitted a sworn statement, but it obviously has its weight is affected by the fact that the members can't quiz him on it. But I suggest that we deal with that in our own time, so that we can deal with our witness for this segment and release her to go and do other things. So that's my suggestion. So we only have one witness this morning. So Ms. Rambauli, I'm going to ask our colleague from the Parliament legal team, Ms. Fatima Ibrahim. You know her because you guys have been doing the arrangements together for this morning to explain the rules and also your obligations and immunities in terms of your participation in this process. And once she has done that, we will then I'll explain what our expectation is of you thereafter in terms of the topics we want to cover, and then we'll get going, if that's okay.
That's fine. Thank you.
Thank you very much, Ms. Ibrahim.
Thank you, Chairperson, and good morning to yourself and to everybody present and on the platform. Good morning, Ms. Rambauli. Can you hear me?
Thank you.
Thank you. Ma'am, you've been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, read together with National Assembly Rule 168, which affords witnesses certain privileges, to appear before the Standing Committee on Public Accounts in respect of its inquiry into the Road Accident Fund. Please be informed that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding that the answer or the document could incriminate you or expose you to civil or criminal proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years. Ma'am, you indicated to me that your preference is to take an oath. Can I please ask you to raise your right hand and repeat after me? I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, ma'am. You're now duly sworn in.
Ms. Ibrahim, thank you very much for that. So, Ms. Rambauli, I'm going to just explain what we're trying to do here. So, ma'am, you are not on trial at all here today. You are here to assist us in a fact-finding mission. This is heightened oversight. As you would notice, we don't have advocates here. We don't have an evidence leader and all of those things. This is simply the committee doing what we call heightened oversight. We are still doing it ourselves, but we do have to ensure that the information that we get from witnesses is as accurate as possible. We are covering a long period of time. We do not expect witnesses to remember every detail about things that happened 6 years ago. The only thing we encourage is that where you you have a poor recollection of something and you think you know where we may get accurate information, you are welcome to say, look, my recollection is this, but I think you would get more accurate information if you ask the Road Accident Fund for this particular report from that time, then the information would be there. Right. So I encourage you to do that, because you obviously are not at the Road Accident Fund. You wouldn't be able to click on your laptop and look for it during the proceedings. We understand that. We will be covering topics that are within the scope of your role at the Road Accident Fund, but also in general terms as an executive at the Road Accident Fund, as a member of the executive committee. That will be also for the purposes of just triangulating information that has also been shared with us. For an example, somebody may say, this was tabled at the executive committee and there was a long discussion, etc., etc. You may recollect that discussion due to its importance, and therefore we would ask you about your observations or views of such a discussion. We also encourage our witnesses to stay away from hearsay. So just stick to things where you were in the room, you spoke to someone, you were copied in an email, you wrote an email, etc., or you saw a report, which is why you're now able to refer us to that report. But if somebody says, you heard someone saying they spoke to someone, I think the best thing to do there might be to say, if you speak to so-and-so, he or she would have first-hand knowledge of it and give you a better answer. You understand what I'm saying? Because we need to include in our report information that people have been able to back up with some kind of first-hand experience or facts. So I want to encourage you to just relax. This is not a trial at all. We're not trying to find anyone guilty. Myself and the members may also ask you later on to assist us with recommendations that would assist the Road Accident Fund and the Ministry of Transport to make sure that the institution runs as smoothly and as effectively as possible on behalf of the claimants, and also it also uses public funds in the most effective way possible. That's our interest here in this inquiry. So you just prepare yourself that the members may ask you for recommendations. You are also free, after having reflected on our discussions today, if you've got recommendations later on, to also write to Ms. Ibrahim and say, look, I've reflected on our discussion, and I think these couple of things may assist the Road Accident Fund, because that's why we're doing this. We want the Road Accident Fund to get into the papers for really good reason, and not for bad reason. So that's the context of our conversation. So just feel at ease, please. I am going to ask you just a couple of questions, maybe for the next 15-20 minutes, just for orientation, so that the members understand your role at the Road Accident Fund. I will just ask you one or two questions about a number of issues that fall into these categories that we spoke about. And then I will hand over to the members to ask their own questions. As soon as they've done that, we are done. We will release you and you can go and have lunch and you will be done. And prepare your recommendations to us over lunch. So the first thing I'm going to ask you to do is to just tell us when you joined the Road Accident Fund, the roles you've played there, and what those roles entailed. It will also help the public who are watching this to get a sense of why you are here.
Good morning, honorable members and the public. Let me reintroduce myself again. My name is Maria Muraro Rambauli. I joined the Road Accident Fund, September 2017. And for me, it was a transition from the private sector. It was the first important public role that I occupied, pretty much my entire life have been in the private sector, and I occupied a position of a regional general manager at the Cape Town office to look after the Western Province. And then that role I occupied for a period of 3 years and 2 months, and then was asked to act in the capacity of a chief operating officer, which was based in Centurion for a period of 18 months. So the reason it is important for honorable members and the public to understand is that the position I occupied was a 5-year contract with the Road Accident Fund. And in 2022, that's when the contract expired and I left the Road Accident Fund. So in a nutshell, when I was the regional general manager, the responsibility was to oversee the operations of the fund for the province, and it take many forms of stakeholder engagement, claims management operations. It also entailed management of direct claims. So we would have what was called rough on the road to reach out to communities so that we are able to serve them. So it was really an engaging role that sought to assist the claimant overall. And I say this because it's different to what the position of the acting COO was. The COO was not pretty much hands-on because it was an oversight role looking after all those regions and the customer service centers. And the structure was designed to take care of mainly the operations. And at a later stage, just before I left, I had introduced a very strong medical management division and an operation actuarial quantification unit, just to assist the operation to make sure that from a claim risk point of view, we were covered. And when I talk about claim risk, it's really just about making sure that you pay the right person, the right amount at the right time. So making sure that the overinflated claims are really, you put a spotlight on them and you peruse them so that ultimately the fund remains sustainable. So that's what the oversight from an acting COO entailed. So it was 18 months there. And I pretty much appreciated the exposure, the experience, and understanding that when you serve the vulnerable people, you have to put your heart in it. So thank you. That's me.
No, thank you very much for that. That's certainly helpful. Can you just say, in the position of acting chief operating officer, what departments fell under your oversight? Just list them. You don't need to explain what they did.
So it was pretty much claims operations, the medical management, actuarial, facilities.
Okay. So let me just understand actuarial. So it was explained to us that there are the guys who do the big actuarial estimates, the liabilities and that kind of thing. And then there were the guys who work at the level of the claim, the actuarial analysts and so on, who would then work out future loss of income or loss of future income, etc., etc. So you're talking about the second group of people in a nutshell. Okay.
All right. And perhaps maybe just to bring context to it, they were insourced because in the past, the RAF had a panel of providers that assisted them through the value chain, right? And part of it was a panel of attorneys, a panel of medical experts, and a panel of actuaries for quantum. And the actuarial component that I'm talking about was insourced internally to replace the external panel of actuaries. Yes.
All right, thank you. So other facilities, I'm assuming that security would fall therein as well, the security function. Would it? Yes, okay. No, that's fine. Let me just ask about the medical side of things then. And that I just want to establish if members can ask you questions about this. So one of the public submissions we received was, in fact, let me start here. So we had one of your former colleagues who works with the medical management side of things. I just forget his name. But he came in on the first week to orientate us, and he explained what the medical management side of things does. You get a report on the medical legal report, or a report from a doctor, etc., etc. The road accident fund, that is from the claimant side. The road accident fund has to take its own independent view of the same issues in order to be able to contest or have a discussion about whether the loss of future income is X or is it Y, and that kind of thing. And also just the medical costs involved in treating the condition so that the road accident fund does not overpay, etc., etc., all of that. So he explained it in that way. But we also took witnesses who also explained things such as undertaking letters for somebody to go and get medical treatment and so on. And one of the public submissions we received was in relation to Sunshine Hospital. The only reason Sunshine Hospital, because we are not the portfolio committee on transport, we are the standing committee on public accounts, the only reason Sunshine Hospital became relevant to us is the high volume of judgments against the road accident fund pertaining to Sunshine Hospital. The interest accumulated is now around 25 million rand on those matters. And obviously that money would prefer goes to claimants rather than going to interest, right? Or towards funding the operations of the road accident fund, technology and so on. So that's our interest in the matter. But we took some witnesses, both from Sunshine, but also the road accident fund on the same matter. Is it something that you came across? So that's the only question I'm going to ask you for now. Is it something that you came across, the relationship between Sunshine Hospital and the road accident fund?
Sunshine was, I think it was a hospital in Johannesburg.
Yeah, in the East Rand, yeah.
In the East Rand. And it dealt a lot with what within the Act is considered medical expenses, right?
Yeah.
So
yeah.
the medical expenses, if I'm to explain, is that you are a victim of an accident, you go to hospital, the cost associated with the acute phase, which is pretty much about making sure that your injuries are taken care of. And then when you finish that, you then move into a rehabilitation, which is a process that assists you and tries by all means to put you in your best possible state, which is the rehabilitation. So I came across it, and my understanding is that under normal circumstances, hospitals, like big groups, are designed to cater for a diverse group of people. And I think Sunshine was an outlier purely because it pretty much dealt with RAF matters. And I think maybe that's why, from a business model, they ended up having troubles or problems, because when you design any business, in this case, now I'm not saying and sunshine, I'm just saying logically, when you design a business, you don't design it with just one client.
With one client in mind,
Yeah, so you want to diversify yourself to be able to cater for a diverse group of people. So for Sunshine to create their business model only to be dependent on RAF was just an anomaly on their side. So I'm neither a judge or anything else. I'm just trying to, explain, Honorable Chair, that Sunshine was just an outlier from that point of view. Thank you.
No, thank you very much. It's something I actually went back and forth with the owner of Sunshine. So his answer was that they actually never used to focus on the road accident fund at all. Over time, they got so many referrals, either from public hospitals, from the RAF, or from ambulances themselves, due to capacity issues in the public sector, that over time they became, the majority of their business came from the road accident fund. I mean, notwithstanding, I just wanted to establish if the members can ask you questions around that. If the level of detail will depend on your job. The other thing I wanted to ask you about, are you aware of the people called claims originators? Did they fall under your area at all or not?
All right. So when I was a regional general manager, I had claims originators. They were a group of consultants who were there to assist for direct claims.
Yeah. Were you around? You were around, obviously, when the decision was taken to withdraw them, because we've had several witnesses who were on that side of things, but also from marketing. From the marketing end, they were told to withdraw any marketing of direct claims, and then from the direct claims people, they were sent to customer service centers and so on, but were no longer there. Were you around that change?
I was a regional general manager at that time.
Okay.
So I was in the regions, yes.
Okay. And then the last question I want to ask you is that one of the things we have dealt with is also pertaining to the panel of attorneys issue. Now, just to be clear, because there is a lot of noise publicly, the committee does not have a preference either way. Where the road accident fund sources its legal services. Obviously, would prefer that as much of that service is insourced, so that the road accident fund can use its own capacity to deal with the matters that it deals with. So this is not what this inquiry is about. What we are about is the consequence of the decision, the financial consequence of the decision, in the sense that we then saw a spike in default judgments. The last time the SIU was with us, they had exceeded 5 billion, which is not small money for an underfunded institution. So that is the one area. Secondly, the number of cases where the road accident fund eventually has to pay interest, there are rate costs, there are sheriff costs, and so on. Because as we were told by the manager responsible for the state attorneys inside the road accident fund, they have instances where one attorney is responsible for over 4,000 claims. Obviously, the person, with the best of efforts, they simply can't handle that much work, right? So what we've been trying to establish is the level of preparation and planning for the transition, so that you don't have things falling between the cracks and then incurring expense in the process. So we want to understand what happened. We want to understand state of affairs now so that we can make recommendations about how to fix the leakage of money. Because, we were told that sometimes there are 3 matters in the same courtroom at the same time in front of 3 judges. They're all assigned to the same person. So the person obviously cannot be in 3 courtrooms at the same time. So they go to the one case. In the other 2 cases, the plaintiff then gets a default judgment because the road accident fund is not there. Now, to your point about inflated claims, the road accident fund may have been able to argue that, nope, this is not R1 million. This is 80,000 rand. You understand? Now the road accident fund pays R1 million when it should have paid. That's our interest. So I just want to be clear that we're not here to debate what the road accident fund should have done. Management can make decisions, and the board that they believe are in the best interest of the organization. We're only interested in the financial matters. So when that happened, were you in the region or were you in Centurion?
So when it started, I was in the region.
Okay, you were in the region, but then, you were in the region when it started. Okay, last
But the
question.
impact was felt in the regions, yeah.
No, of course, I mean, I can imagine that it was, and you can talk to the members about what the impact then would be, because I'll give the members an opportunity to ask questions. Then the last thing, which I had forgotten, I know I said the attorney's issue was the last, pertained to the panel of medical experts. So they were the panel of attorneys, panel of medical experts. There are changes across both, and some medical experts are tied to attorneys, others not, and then there is an extension of the tender because you need medical experts and so on, and then the process appeared to have gotten very confused, where in some instances there were medical experts who did work on behalf of the road accident fund, were not paid for a long period of time. Some of those matters have since prescribed. We were told about instances where at some point the road accident fund then had a panel of about 80, but you would find that somebody who is in Vicksburg in the Free State has to travel to Johannesburg to access a particular expert. Now, one of the things that the committee is concerned with is access by victims who have broken bones and all manner of things. So you just think if somebody has got to travel 400 kilometers or whatever the distance is, it's uncomfortable. They might not have the money. If the road accident fund is helping, it's now spending money on other things just to access a report and so that's the reason we are interested in this field. Again, we are not here to tell management on how to organize the business, but how that business is organized. It's got to produce an outcome that serves the claimants and is financially efficient. That is our interest in the matter. So I just want to understand what the nature of your interactions with issues around medical experts was, and then I'll hand over to the members.
Right. So I think let's start with the medical management and just explain broadly what they do, what's the intention, and how they facilitate the process of ultimately determining and quantum and payment. So and for me to be able to do that, I'll just take you through a journey of how things happen so that we move along together and we try to fill the gaps where the gaps exist.
Awesome.
So you are in an accident, you are in an acute phase. What normally happens is that you will go to hospital, you'll be taken care of, and after that you will be discharged. And if you are on a medical aid, your medical aid will pay that. If you are not, you will probably go to a public entity. And then once that is done, you have got an opportunity when you come back to complete the RAF Form 1, which is a form that allows you to claim or to let the fund that you were in an accident. And that form has got the current act, and I don't want to be controversial. I'll try talking you through so that you understand the RAF form and the RAF Form 1. So just bear with me there. So the act in its current form tells you that you must complete that form, and that form must be accompanied by an affidavit from you, the claimant, that confirm that indeed you have been in an accident and what really happened. So that's an affidavit. And the form requires you to also have a statutory medical report that is either completed by either the superintendent or the doctor that saw you while you had an accident, and it is purely to confirm the injuries and some form of identification. So the reason why I'm telling you this is that you actually didn't have to wait for a year to be able to lodge your claim. You can lodge your claim for other services or other heads of damages or product to be able to be in motion. So once you have lodged this claim and you have told the RAF that you have been in an accident, the RAF must be able to do their due diligence, and in the main is to assess liability. Is it something that really warrants the fund to pay? So that's the first step. Because once liability has been confirmed, or the RAF has confirmed that indeed this is something that we would pay, there was what is called an interim undertaking. It's an interim because it assists you in the meantime while other things happen to be able to go seek medical attention, especially for the ones that are not able to access medical services freely. So that undertaking is the one vehicle, obviously once liability is confirmed, that allows you or opens up the medical management aspect, where within the RAF, the medical team will then assess whether the kind of services that requires it's in line with our protocol and guidelines of how treatment needs to be done. So that's the first thing that I wanted to just highlight, that the medical management team would also facilitate that. It's called an interim undertaking because it is to open up that kind of services for you to be able to get medical help. And that's why we had a medical unit within the region. Once that is done, depending on the heads of damages, there is, something that is called MMI, right? Which is a terminology that is used to allow the injuries to settle, right? And the rationale for that is that we don't want to pay too early and then you complicate at a later stage, or pay too early when you could recover, right? So you allow a period of a year and then you go into a full swing medicals to really then, after that 1 year, to check the extent. And that period, it's then kicks off the process of the medical report, statutory medical report, where depending on the nature of your injuries and depending on what heads of damages or product you are claiming, there's a set of reports that's required. The first type of reports, if you have had a head injury, you will go and seek a neuros and neurosurgeon and people that deal with the head, and they will try to establish the nature of the injuries. So we call them the primary specialist. Once they've done that, it then goes into an industrial psychologist and an OT to then assess what impact those injuries had on your livelihood, your activities of daily living, but more importantly, on your future prospects of employment. Once that is done, that report gets given to an actuary who will then quantify for future loss of earnings. And then you will then have something to put on the table to say, this is what we believe it's a suitable amount of money that compensates you due to the accident that you have had. In the past, we would have these experts being appointed by a panel of attorneys because they used to work hand in hand. And what had happened is that when the panel contract expired, it meant that because RAF was not instructing the medical expert directly, they would be given the work through the panel. There was a mechanism that we needed to be sure that indeed you were asked. So it was just a proof that you were asked to do this kind of services so that your claims can be paid. And in the past, by the way, these medical experts, once they have confirmed and they have provided all the documentation, they are either will be paid through their panel or where the warrant could be paid directly. So from a process point of view, that's what happened. It is critical for me to just explain the importance of having good, solid report in order to determine the quantum. If you don't have a good report, it does contribute to failure to determine good quantum. But more importantly, that if you don't peruse this report, you may end up ultimately also overstating whatever the quantum it is. So that's at a process level. At an RAF level, where the claim officer's role was to say, the claims officer will work with the medical people who will then determine is it indeed a serious injury or not. And then once they have got that, the officers who are legal people can go out there and argue the point confidently because they would have been supported by this team of medical people who, by the way, understood medical context and the severity of the medical conditions or diagnosis that they had. Once that is done, then the claim will then move forward and we will either issue a future undertaking which will be subjected to the clinical entry criteria and the protocols that needs to be applied, purely because you don't want to have an open-ended medical certificate because it is also would be prone to abuse. So that is in a nutshell what medical management is. What it also just does, Honorable Chair, is that in instances where, for an example, you didn't, you were very happy with the plaintiff report, there was no need for you to duplicate because we understand the cost implication. So if the report is written correctly, you need to peruse it and then you take it through the value chain. So yeah, I think in a nutshell, that's what medical management portion is. And I know that sometimes people confuses medical management with invoices. I listened to some of the conversations that were had here. a medical invoice, pretty much nothing else other than a claim that tells you you were in hospital on this date, up to this date, and this is the treatment that you received, and it will have a line level item, but it is not, what's the right word? It's not a report. It's not adequate for anyone to derive meaningful information to come to a conclusion that indeed you have got a legit injuries. It does confirm that you're in hospital, you had injuries, but you will still need a medical report to be able to ascertain the extent. So that's what I wanted to elaborate on, to say a medical invoice on its own, it's not adequate for anyone to derive meaningful clinical information to determine the extent of the injuries.
No, thank you.
So that's on medical.
Oh, sorry?
So I was just saying that is that on medical. I was going to come to panel.
Oh, yeah. Okay, please. Yeah, please go ahead. Yes.
Okay. So in terms of panel of attorneys, like I said, I was in the region at that point, and it came to an end, I think, towards the end of 2019, I stand to be corrected. But then there was an extension that was provided for an additional 6 months, which would have made it to come to an end April, May, around that time. And the instructions to the region was that we needed to start engaging with the panel because I think a letter was sent to them to bring in the claims, and there was a hierarchy or an algorithm of what are the claims that needs to come in, when, and how. And we started engaging panel. It wasn't easy, purely because panel didn't submit those claim files. But I will not talk much about the panel. I just want you to understand the complexity that came in post May, when we didn't have representation, right? Because
representation by you mean legal representation?
Yeah.
Legal representation. Okay. Please go ahead.
All right. So by design, already by now you know that RAF it is a litigious business, right? So from a practical point of view within the region, what it meant is that summons, when served, were not defended. And if we had matters that were going to court, we weren't represented. I recall at that point, I went to approach Judge Sope because he was for the Western Cape, and I asked him for indulgence. I went and I said, this is the situation. This is the model that RAF is moving towards. What I ask for you is to give me an opportunity to settle these matters and to make sure that I don't run an amok out of your courts. And this is the plan that we are going to implement. And I had a very good, strong claims monitor in the courts, Mr. Petka. And we tried by all means to make sure that matters that needed to run, the officers put an offer in and make sure that we settle as many claims as possible, purely to avoid default judgment, because naturally, if you're not represented, you will result in default judgment. So yes, we did try whatever, but it doesn't take away the fact that we were not represented, and it took a long time for for the fund to get representation. Yeah. And at a later stage, then we had internal resource legal representation. And even when they were there, they were never enough. I mean, we had about 88 panel of attorneys who had, extensive team around them to support them. Vis-a-vis, at that time, I think we had 87 in-sourced legal representation. The maths doesn't math, right? You were not going to have adequate representation. So by design, we were bound to have a form of default judgment, because it was never going to be a one-on-one. So for me, I think that's the lesson, that if we are to insource completely, the recommendation should be that we have to capacitate the legal team to be able to go and represent RAF in its current form. So that's the first recommendation. It will definitely be that they are capacitated, and in the failure of capacitating them, then we are just rendering the fund incompetent.
Thank you very, very much. You've actually covered what would have been my follow-up question. The only thing I'm going to ask is, my expectation is that if an organization such as the RAF or any other is going to undertake such a complex change, in other words, panel of attorneys, we're doing away with it. Panel of experts is linked to, they get their briefs from the attorneys, right? A lot of the time. So the two are linked. So I am now disconnecting this one that gives the work. There are reports which are being prepared right now for attorney A and attorney B and attorney C, and for like any number of claimants, right? About any number of claimants. That if I am going to make this change, I am going to appoint a project team or a project manager, right, to work out the complexities of doing this, what the critical path of the project is going to be, how long it's going to take, what the resourcing plan is going to be, so that I don't have the problem that you are describing, which is matters undefended, default judgments, the court system getting clogged, and then the medical experts being disconnected. Now you have to find out who was dealing with what, if you are within the road accident fund environment. That is my expectation of an organization that is doing this kind of transition, in order to avoid inconvenience to itself, to its clients, i.e. the claimants, but also then to prevent financial leakage. Is that expectation unreasonable?
I don't think it is unreasonable. So let me qualify my statement. So I did tell you that I was not in EXCO then, so I was in the periphery.
No. We're speaking in general terms, yeah.
Yes, but the logical explanation for anyone running a 50 billion entity would be that firstly, you need to have a business case. The business case must articulate exactly what problem are you solving by articulating a problem statement, and then quickly summarize the strategy that you are going to employ to be able to get to where you want to be. Identify what are the risks, what are the opportunistic costs, and mitigating plans, because not everything, Honorable Chair, it goes the way you want to. You may plan 150. By the time you cut, it's completely different. So it's a living document. That business case is a living document that says we want to do this. This is why we want to do it. These are the values that are aligned to this, and we are going to derive these benefits. And as we move along, we're going to check, are we still going the true north where we're going? So I would want to believe that that business case was made, or maybe was made. I mean, I'm just telling you what a normal organization would do.
Yes.
It would have been done so that you can understand the impact it is going to have on the ecosystem.
Yeah.
And the plan, the rollout plan, because I don't know about other people. It takes a long time sometimes just to put an advert, interview people, and put them on the seat and ready to be able to do the work that they do. So you have to have a project plan that says, if I am insourcing, these are the timelines. This is how I'm going to ramp up resources to be able to meet my demand. So I'm working off the assumption that there was a plan. I might not be privy to it, but highly likely that such an activity of this magnitude would not have had a plan.
All right. No, thank you very much, Mr. Rambauli. Honorable members, may I give you an opportunity to have a conversation with our witness in the manner that we normally do. So I will take hands. Okay. So what we'll do is we'll take 2 hands, and then we'll see how we do, because I'm also keen to give Ms. Rambauli a break because she's talking the whole time. And then
fine.
So maybe let's take 3 hands. There are 2 for now. Honorable Beasley, you go. So we're working on 15 minutes. You go, and then it will be Honorable Atkinson, and then it will be Honorable Skosana, and then we will take a break and come back in that order. Please go ahead, Honorable Beasley.
Thank you, Chair. Greetings, Ms. Rambauli. Am I saying it right? Close enough?
No. It's Rambauli.
Okay, thank you.
Rambauli.
Thank you, and greetings to colleagues. So, what happened to the CEO before you? Was there a CEO?
Yes. Before me, it was Miss Lindelwa Jabavu Tingwayo, and she left. That's why I was asked to act in that capacity. And
when you say she left, did she resign? Was she suspended, dismissed? Do you know?
I'm none the wiser, Honorable Beasley.
Okay. And at any stage were you acting COO whilst the permanent CEO was there?
I acted while he was there for 18 months.
So you were acting COO whilst the permanent COO was there?
No.
Okay.
Yeah, no.
Okay. So you came in after him. And then just why did you leave the RAF?
Contract ended, I did say.
Okay. So your contract ended.
And I had applied for a chief claims officer, and I didn't get it.
Okay. And then you mentioned that the panel of attorneys, it had quite a big impact on the regions, and you did explain default judgments, but maybe if you can just go, what impact did it have on the regions?
The cases were not represented in simple terms.
Okay. And then you mentioned a plan that. Did you ever see a plan? Was a plan ever discussed? I mean, surely as COO, when you went there, you would say, "Can I have a look at the plan?" Did you ever see a plan? Did you ask
never
for a
saw
plan?
it. Never saw it. But you are more than welcome to ask the board.
I'm asking you, ma'am. Did you ever see it? I mean, as COO, surely it's quite an important document as being part of the executive to say, we're going a bit sideways here. Let's have a look at the plan.
Never saw it. Thank you.
Okay. And did you ever ask for it at all? I'm just asking if a plan actually existed.
I wouldn't say, because by the time I got to be the CEO, it was towards the end of 2020.
Okay.
And
then,
we were trying to, we were now in the mode of making sure that we put everything and our energy in solving the RAF problems at that point.
And at any time, and this is not just, it's not just a question, were concerns raised with the new operating model at all? You know, in the executive, where they're saying, "Hey, listen, this is not working. It's just chaos." Were those concerns ever raised in the executive at your time?
So I think we knew that at the bare minimum, the legal representation was not adequate. So there's no lying about it. It really, like for like, we had very less human capacity to be able to run adequately within that space. So that was acknowledged, and that's the reason why even the human capital ramped up, put in advert, made sure that we have got adequate human resources to be able to deal with the matters. I mean, some region didn't have representation, so it was never perfect, but we knew that we needed to correct it.
Yeah, when you say it never was perfect, I don't think it ever came close to perfect. And ultimately, the end of the day, it's public money that's been gone down on default judgments. But the question I'm asking was it ever raised it's not an accusation, it's just, were concerns ever raised in the executive that, sure, we got a big problem here?
We did.
And what was the plan? Just to ramp up slowly?
Not ramp up slowly, but ramp up strongly and fast.
But the ramping up didn't happen. I mean, as we stand now, they're still very, very short of representation. So the ramping up never happened.
I wouldn't know what happened after my 18 months, but what I do know is that I did, because I was part of that EXCO, I did indicate that we are battling, the regions are battling, and worked with the head of legal. That then it was I had a very strong head of legal, Mr. Justice Mudluli, and just trying to make sure that we don't leave RAF exposed. Yeah.
But just for the record, the RAF was exposed because those default judgments are still going on at the moment. And then, did you play a role at all in the new RAF form?
Yes, I did.
And what role did you play in it?
It was to craft an RAF content that would assist the legal team to be able to publish it for comments.
Okay. And then just you spoke earlier about compassion and nice terms there. But what has come quite clear is this new form is anti-poor, because you need a lot of money to access it. And people talk about this interim undertaking, but the reality, that's not issued. So I always refer to my mother in a small village. The chances of her ever submitting a claim at the moment is impossible, unless you got a deep pocket or you use an attorney who's prepared to help you. It's just not going to happen. Just your thoughts on that?
So basically, if you solve a problem at the wrong level, you'll not get to where you need to be. I don't think the form it's an issue. It is the process around the form that may just be an issue.
And when you say the processes around the form, can you just elaborate?
So the form's purpose is to get you information, right? That will assist you to be able to kickstart other processes, right? So it is in the decision making that I get where you are going with what you are talking about. So if you have a form, and I don't want to infer, because I have left RAF 3 years ago, and if I tell you what I'm telling you, it means I'm telling you what I would have done, which is not the point because we're not here to talk about how I would have navigated the space. But I think I don't want this committee to assume that the form is wrong. It's everything around the form that makes access a problem. And we have to get to that space that says, if this form is intended to bring this and this, how do we capacitate the claimant, capacitate RAF so that, and also the plaintiff collectively, to ultimately make sure that the claimant gets their money on time, of good quality value, and the fund is sustainable. You cannot not look at it in that manner, because if you just look at it in one silo mentality, it means that the other two will suffer. So let me tell you what I had in mind when I derived this form. It came from the claims model. Remember, previously they used to be called Chief Operating Officer, and then I said we need to transition into Chief Claims, because the core of this business, RAF, is about claims. It's a claims organization, and therefore you need to transition yourself into a claims management organization. And with that's where the form came. The first component of the claims model was around operation. Solidify your operation in such a way that you know what, you can consistently derive same output all the time if your inputs are the same. The second component was around claim risk, which was around fraud, waste, abuse, and errors, right? To make sure that the fund is insulated in a manner that we can safely say we are sustainable, and me as an executive, I can sleep at night. The third component was around customer experience. While you're doing your operation and you're managing your risk, make sure that you don't leave the claimant outside. So it was in this context that we wanted to pay claims within 120 days. And we knew that the type of claims that we had was just a shell. You could not, derive any meaningful information. And therefore we said, if we wanted to pay claims within 120 days, what are the things that we require to be able to facilitate that process? So that's the context of the form. The form was to say, I actually want my claimants to be paid as quickly as possible without delays, and then that value chain can proceed. What ultimately ended up happening, I listened to yesterday's conversation around the form and the system that the RAF can explain to you. But I think the key thing is that you, as you're managing your claims management process, you ought to design it in a manner that takes into consideration exceptions. And I don't think that the form was deliberately designed not to be compassionate towards our claimants.
Oh, maybe good intentions, but shocking outcomes. And then just the last thing, there were a lot of staff suspended in the claims department. Did you play a role in that? Were you in any way, when I say responsible is the wrong word, but were you a lead in that at all? Did you have any input into that actual system? Because it just seems quite bizarre that a lot of claim capturers were released in the midst of all this change in the operating models. As your time there as Chief Operating Officer, did you play a role in that at all?
So by the time they were released, I was already gone, but I can tell you the genesis of what had happened for context. So RAF had gone to seek indulgence to pay claims within 180 days. And for you to be able to pay a claim, that claim needed to have been loaded on the offer system for it to be paid. And what had happened is that we had gone out. I had issued a directive to plaintiff asking them to send us all the offers that are not loaded. Subsequent to that, I made a commitment to them that I will send them their RNYPs. And I said, moving from this step forward, all officers needed to load their offers. And they weren't loading, Honorable Beasley. They were contributing towards offers sitting there, and at some stage there were offers that are close to a year that were not loaded onto the system. And when that happened, I seem to recall that I had a conversation with the CEO, who then said, somebody called me and said the officers in the regions are not loading the cases because there is fraud going on. And when we did a deep dive and started looking, there were lots and lots of offers that were not loaded. He then called me, he called the chief human capital, both acting, and he says, we must get to the bottom of this. And that's when the first initial investigation started. In my knowledge, in that meeting, he never said these people needed to fire. He said, go and investigate, and if anyone is found wanting, they needed to account.
Okay, thank you. And just comment on that is maybe it was a management and leadership as opposed to individuals. But I'll rest it at that, Chair, and thank you for the engagement, and have a good day further if I don't chat to you again.
Thank you.
Thank you very much, Honorable Beasley and Ms. Rambauli. Can I give a chance to Honorable Atkinson?
Thank you very much, Chair, and good morning to Ms. Rambauli. Ms. Rambauli, would you be able to give us an indication of what the working environment was like when you were there as COO? Whether there was whether people were open to other suggestions, because what you said to us earlier about the whole issue of having a plan in place before doing away with the panel of attorneys, and knowing what your problem statements are and how you're going to solve that particular problem, makes ultimate sense, but quite obviously didn't appear to be carried out. And I'm just wondering, was it an environment that was actually open to suggestions or open to other ideas?
Personally, I presented a lot. I'm a self-starter, and I want to indicate to this committee that I was amongst the executives that would present a lot. I worked from the premise that it doesn't mean that I'm a shooting star, but every month I will have something that I would want our executives to know that is happening in the ops area. I would present how we could improve RAF. I would present how the organization can improve. So I think from an EXCO, which is a structure, I for one, I'll speak for myself, that I had given myself permission to be who I needed to be, and at any given time I would really put my best foot forward. So at that platform, yes, I think I would say yes. I do want to also say, Honorable Atkinson, that when you work in any organization, you will always have characters. that may not agree with you, that may not see eye to eye. So as an executive, I know that you don't have to like me. And as long as we all understand that we came into this organization to make a difference, we can agree to disagree. And I think I operated from that space that said, I'm an executive. No one owns RAF. We all want the best out of RAF, and wanted to make sure that during my tenure, I made a difference. And I do want to believe that although I ended up leaving, there's a lot that I have done. I would have done more, but I left it in a position that it had content, it had strategy, it was very clear what I needed to achieve at the RAF, and everyone else was brought on board in terms of where I see claims and what my vision was around it. So that I've done. I will not enter into or venture into personalities because you find it everywhere. It happens.
Mrs. Rambauli, just as a matter of interest, you mentioned about your vision around claims. What was your vision around claims? I mean, you mentioned the fact that you often gave suggestions to Exco and ways that you could have improved the business. What were your suggestions around the way that claims could be improved? And also, did you ever bring up the issue of the lawyers and the lack of legal representation for effectively a litigious organization, as you put it?
Right. So my approach, my vision was that our primary role must be that 80% of our claims must be settled without litigation. Litigation must be by exception. And for you to be able to do that, it meant that I needed to put in processes that were solid. And by the way, I'm a green belt Lean certified person. So I engaged the organization with the business analyst, and we started mapping out processes to understand what needs to be done. And those processes informed, by the way, the design principles for us to be able to go out and require this integrated claims management system. And what I also wanted to do was to say a 50 billion organization can't operate on paper, because when things happen, information, content, insights, it's hidden into that paper. So I had also requested that we go out and get a system that was going to digitize our environment. And the third one was to say, once we have done this, we must layer this with some, insights and data analytics that will begin to allow us to have, some AI components to it for consistency, for decision making. But more importantly, Honorable Atkinson, that the knowledge does not sit just purely in the heads of the officers. So you begin to create scale and information content and standardization within the organization. So that was my vision. And I left before I could indulge myself. But yes, the strategy was approved by the board. And we had gone out for the integrated claims management system. And when I left, they were in the phase of really just negotiating the terms and conditions and really understanding what the claims management system was going to be implemented. So yeah, to a certain extent, I'm happy that I was there, and I'm happy that I was able to share my knowledge. And yeah, time ran so quickly.
Yeah, no, thanks very much, Mrs. Rambauli. I must say I completely agree with you on that. of claims could actually be settled without reverting to the legal process, and that actually really should all be done in-house. And I do think that in an earlier iteration of the Road Accident Fund, that was what was done, was that it was by matter of exception that things actually went to court. But I think really that what one should be aiming for is precisely what you're saying, where the majority is actually done in-house and doesn't need the introduction of a legal process. Mr. Rambauli, one other question to you was, you mentioned the fact that you were running the Western Cape office of the Road Accident Fund, and that you did meet with Judge Slopie and came to some agreement with him around the handling of claims in the Western Cape court. And you mentioned the fact that you made offers before these got to default judgments. What level of default judgments did you have at that time? I mean, did you manage to avoid almost all of them? I mean, what would you be able to put a quantum on what those default judgments were?
In the past, default judgment was a swear word, I must say, Honorable Atkinson. And there was a default judgment system, and they needed to be reported. They needed to go to OPSID. So in the past, it was not a norm to have default judgment. I can confirm that. You will have them here and there, but it was never the norm that you had default judgment because matters were properly represented. And if they were not represented, there was an SLA that we signed with a panel of attorneys that subject them to a certain ways of behaving. And if they didn't behave in a manner that they needed to behave, we could kick them out of the panel. So default judgment, indeed, it was never a tolerated behavior within the RAF in the past. And if they happened by exception, and corrective actions was taken. And I mean, it started coming in because of the panel of attorneys that were limited. Thank you.
Thank you very much. I appreciate your insight today, and thank you very much for your insight and evidence as well. Thank you.
Thank you very much, Honorable Atkinson. We'll go to Honorable Skhosana.
Thank you very much, Honorable Chair, and good morning to you and to all honorable members and other stakeholders present, and also to Ms. Rambauli. Good morning, Ms. Rambauli.
Sorry, I realized that I'm on mute. Sorry. Good morning, Honorable Skhosana.
No, thank you very much. No, thanks for the opportunity to have a conversation with you. There's this issue of the expansion of the close protection services for the former CEO. You remember that there was a limit that was set by the board of 480,000 per annum. So there was an expansion. I don't know whether was it during your era and you had any role to play in that regard.
Yes, I did ask specifically with regards to that for the RAF to provide me with information and content so that I am able to provide clarity to the committee. The onset of the CEO's close protection was started through the board. And I remember very well submitting a board content to inform the process and what we have done to be able to allow it to go through. There are two issues that I want us to get, or rather to just ventilate in a manner that would assist us to understand what had happened. There was a fringe benefit which was assigned a 480K per annum. And this was the terms and conditions as part of the CEO employment contract. And when the first incident of his security threat came on board, the then chairperson called me and asked me to look into this. I then asked, there was a gentleman called Madume Lehome, yeah. I then said, there is this request that we need to prepare so that we can take it to the board. It's around the CEO security. This is the context. The memo is 480. Let's get rolling. Let's get quotation. He then did. And then I think there was one company that complied with the threshold of 480. But through several conversations, it became very clear that this other organization is not able to provide that services that they've sent through to us. And then I think he then went again. I think we went 3 times trying to cater for it within the fringe benefit scope. And we were not able to succeed in that context. Up until there were several incidents. I think the CEO's car was burglared. The chairperson's house was also burglared, and the chair called another meeting. And in that meeting, there is, I think, I will direct you to that. There is a resolution that was taken in that board meeting that says that right now, because of all these incidences, is there no way that the CEO can be afforded an opportunity to have close protection as per the RAF policy? And the RAF policy requires that the EXCO, not the board, approve it, because then it becomes not just for a CEO, but any other employees who's appointed by the Road Accident Fund. If there is a threat that is warranted, then we are able to cover for it. I was then asked to work with a certain gentleman, which was in June 2021, called Mr. Msiza Stephen, because he was brought in to the Road Accident Fund as an expert in security. And I worked with Mr. Msiza to be able to submit a memorandum to EXCO explaining the context and allowing the EXCO to make a decision whether we evoke the close protection policy or not. And indeed, EXCO approved it, because at that point, everyone else in EXCO was like erring on the side of caution. But what we also done, Honorable Skosana, was to say, we will approve this close protection on a month-to-month basis, meaning it will be utilized while there is threat. and it will be for a period of 12 months. And the process that was then handed to supply chain to make sure that they effect the decision of EXCO in invoking close protection so that the CEO can be protected. I hope it answers your question.
Yeah, so I hear you when you say the EXCO approved it after you and Mr. Msiza submitted the memo to EXCO. Board involved in the process, or the board was got a report after you have done all that?
We're breaking, Honorable Skosana.
Yeah, I'm asking about the involvement of the board in the process, because you indicated that you and Mr. Msiza submitted a memo to the EXCO, and then EXCO then took a decision to do this expansion based on the threats that were there and the preceding incidents that happened, like the part in the house of the CEO and the house of the chair and all that. So I'm just asking about the board. Was the board fully involved in the process, or the board got a report after already you were taking the decision?
So the board was just informed after we have concluded, but the board had been in the know prior to evoking the close protection policy as per RAF, because in the last, I just don't have that document, but there is minutes. If you go to the minutes of the board, they will assist you to follow the chain of things in terms of how things happened. So it was, the last meeting was the board where we said, where they then said, then this now falls in the purview of management, and therefore the management needs to do what they need to do. And we then left the board, and then we went into EXCO to make sure that the process, is kickstarted from management point of view or EXCO point of view. So the board was not actively involved in the actual sourcing, but they knew that the policy does allow for close protection services for anyone who is subjected to a threat.
So now the fringe benefit limit of 480, because I think we are talking about it, that you said this thing will be done month to month for a period of 12 months. Then what happened after 12 months? Does it mean that if the threat is no longer in that way, maybe it has reduced? Does it mean then you had to revert back to the 480, or you then after amended the fringe benefit policy to cater the extra 150,000? Or the fringe benefit as we speak now is still at 480?
Yes. So the fringe benefit aspect would have been, because there were terms and conditions of his employment, he could have negotiated it to go up with the chair or with the board. I don't know. But what is critical, which I think you are getting to, is the issue of that, it was a month to month for a period of 12 months. When that happens, what happens, right? Do you go and conduct another assessment? Does he go and evoke and utilize this fringe benefit or not? I don't know what happened after that, but logic dictates that if a contract or a memo or whatever that has been approved is for a period of time, by that time when it ends, then you end. And then if he needed or if he wanted to use his fringe benefit, he could have used it, because this had nothing to do with his fringe benefit.
Okay, no, thank you very much. I think there's a day coming to a different matter now. I think there's a letter that you issued, which is dated the 2nd of November, 2021, which permitted payments to attorneys without prior authorization for medical experts. What was the basis for the issuing of such a letter? And did you consult all relevant stakeholders before taking that decision?
No knowledge of it. I would really like if somebody can just send through to me, so that I can have context of what is talking about. So you're saying it's November 2021?
Yeah, the 2nd of November 2021.
Are you able to read it, or is it going to take time?
I don't have it here now on my notes, but I know that I do have it somewhere. Maybe let's pass it for now. I will try, if I can get it later, I can send it.
I can assist, Honorable Skosana, and stop your clock. I can assist because I do have it to hand, so we need to help Ms. Rambauli deal with it effectively. So the letter is from the 2nd, it's a directive. It's directed to law firms. It's written on the 2nd of November 2021. It is then retracted the next day, but I will tell you what the subject is and maybe read a couple of paragraphs, and then maybe that will jog your memory. It's regarding the payment of expert invoices by the Road Accident Fund. And it is written to the former panel of attorneys. Do you remember that? You remember that matter, right? So it says, basically it says in terms of the clauses 16, 17, and 19 of Annex B of the attorneys SLA, the former panel of attorneys were required to obtain prior authorization from the RAF before instructing assessors, advocates, and experts. The SLA further provided that if authorization is not obtained for instructions, the fund will not be liable for any of the fees and disbursements charged. It has been established that your firm has failed to comply with the above requirements when instructing some assessors, advocates, and experts. The IRAF has assessed the non-compliance and the effect it will have on these experts. The assessment extended to the legitimacy of the services rendered and the benefit to the fund and claimants. The fund has decided to make payment for invoices where prior authorization was not obtained by your firm to ensure that the experts are not prejudiced by the non-compliance. To ensure that the experts receive payment for the invoices consequent to the RAF paying the said monies into your firm's account, your firm through the MD or managing partner is required to sign an undertaking that payment will be made to the expert's account within 10 days of the fund effecting payment to the firm. The undertaking attached to this letter should be signed and returned to the RAF to trigger the payment process. For any queries, kindly contact the panel management unit. The next day, a letter was dispatched by yourself to the same group of people because it doesn't have a particular person's name. I think it makes clear that it's sent to a group. Our letter dated to November 2021 refers, a copy of which is attached herein for ease of reference. Kindly be advised that the RAF hereby retracts the aforementioned letter. That is what Honorable Skosana is referring to. I'm hoping that this assists you then to answer his question.
I would not recall. Did I sign the letter?
You did, yeah. You signed both letters, yes.
Both
with
letters.
your hand. Yeah.
All right. So it's fine. I think what I do need to do is just to get context of why. But the idea is that you would not have allowed any, funds money to be processed without following due diligence.
So, Honorable Skosan, I don't want to ask a follow-up on your behalf. I was helping with reading the letter.
Yeah, so, no. Makes sense.
Over to you. Back to you, yeah.
Yeah, all the typical that Mr. Rambauli seems like she does not remember the matter clearly. So I think that's the difficulty that we are having because I think she's correct. How can you issue such a letter? So I'm also worried about that, as though it was retracted the following day, but as to say, but why was such a letter issued in the first place, and as to whether the relevant stakeholders consulted. Somebody issue a letter today and retract it the next day, it may mean that there was no consultation before the letter was issued. Maybe after the letter was issued, other key stakeholders then came out and to say, but why are you issuing such a letter? And then the next day it was retracted. I mean, it's quite a controversial incident that first, the content of the letter, but secondly, the fact that just the next day that letter was retracted.
Makes sense.
I don't know if you've got any comment on that.
I concur with you.
Yes.
I don't remember, and I don't remember the details pertaining to why I would have come to that conclusion. But your thinking is absolutely spot on, Honorable Skosana. I take your point.
Honorable Skosana, are you still with us?
Yes. I hear Mr. Rambauli was breaking, but I think I've got the gist of what she was saying. Yeah, maybe my last question, Chair, is with regards to the issue of Sunshine Hospital. I heard your comment earlier, Ms. Rambauli, that you can't have a hospital business that is based squarely on RAF business. Now, but my understanding, like the chair indicated, that they had other activities prior to the RAF business, prior to RAF sending people there, prior to other government institutions sending people there. It was just a normal private hospital, like any other private hospital that assists anybody who come with a medical aid or with cash or whatsoever. But I think we should agree that if you've got a business, you see, if you've got a business, say you are selling bread and milk, and you find that you are giving people credit, you are allowing them to take bread on credit, to take milk on credit. If the people that are taking bread on credit are not paying you, and those that are taking milk on credit, they are paying you consistently, at the end of the day, the entire business is going to be affected. Because those whom you are giving bread on credit, even if they did not pay, the money that you generate from the milk, we are also going to use it to go and buy bread, a stock of bread. So the more those who are getting bread not paying, it's also going to affect even those who are buying, the milk business. So the entire business is going to collapse. So our understanding is that RAF contributed seriously to the collapse of that particular hospital. Because that hospital, it was operating like any other private hospital. But then with the RAF business coming in, it also affected what they were doing initially before RAF came in. That's why the entire hospital had to collapse. I don't know, what is your comment on that?
Yeah, I do empathize with the circumstances around Sunshine. And I don't have further inputs that I can assist, purely because I want to believe that if Sunshine was a private hospital, they really needed to de-risk their business. And by saying de-risk, I'm not saying they should not have serviced RAF claimants. They should have continued, but making the entire hospital, everything dependent on RAF, it's a decision that they make. And with any decision, there are consequences. And I can only sit here and empathize that it really broke their system. I actually was not a participant in the breakage of the system. It fell apart because of its essence.
Thank you very much, Honorable Skosana. I don't know if you can hear, because we did have some signal issues. But I'll stop the clock now. Ms. Rambauli, we are going to take a break now as promised, but I just have a couple of follow-up questions. One is to test the consistency of what we've been told before. So apparently there's something called the RAF2 form. Are you aware of the RAF2 form?
Two form, RAF1 or RAF2? I have no idea.
So RAF2 is the form for medical services.
Mm-hmm.
For medical treatment. So RAF1 is for the claims process. RAF2 is for medical.
Is it not the RAF4?
It could be, but it's not one. Okay, so let me just make the one for medical.
Right, for general damages.
No. So for you to access medical treatment. So basically, and I know maybe you've been away for some time from the road accident fund. Here's what we were told. You can fill in. So there's a RAF1 form. The RAF1 form is, well, what it is, right? And you and I can talk about it later. But the RAF2 form is what you also fill in together with the undertaking. Remember the undertaking letter for you to get medical treatment.
Okay.
So let me explain what Ms. Mthethwa said. Ms. Mthethwa used to work for the RAF, right? She was in the region, in the Limpopo region, with overseeing claims originators. So what they would do, they would do is so some patients, some hospitals would not have capacity, and the apprehension was that if the patient is not treated, then the medical costs is not treated on time. The medical costs long term may escalate, and therefore that patient could then go to another hospital where there was capacity. It was either a public hospital or a private hospital, but at least the patient would have a letter from the RAF undertaking to pay because they themselves don't have the money or medical aid. Right, so that's what it was. But that same patient then had to fill in another form, right? And this form is what then releases the undertaking letter. My understanding may not be exact, but the bottom line is you can go to another medical facility, whether it is a public or private hospital. Right, depending on where you are situated and the issue that you're looking at. Are you aware of that process? We did canvass with other people, and they said it is indeed so. Are you aware of that?
So when I spoke about the interim undertaking, you remember?
Yes, were you talking about the same thing?
Yeah. So I just didn't remember that it's a RAF Form 2, but it's called supplier claim form.
Yes. So basically, they don't just give you a letter. You have to fill in something for you to get the letter, because otherwise the letter can be produced anyway, right? So that's what I'm referring to. Now, what we were told, and I'm just introducing these two things. I'll leave the discussion, then we can canvass it later or with the members. So you could go to any hospital, basically, right? Where to any medical practitioner. So if you needed a specialist, something they happen to be at Life Healthcare somewhere, you would go there, make an appointment, and you'd produce this letter, and you would get treatment. So that's one. So that was the one category of people that were going to Sunshine. Then there were there was a second category of people. In fact, there were three. Second category of people were referred to Sunshine by public hospitals. So the hospital superintendent would write a letter transferring the patient to Sunshine Hospital due to capacity constraints within their own hospital. So that's the second. The third instance was an ambulance picks up people at an accident scene. It then shops around for somewhere to take them. And if there's no capacity, they take them there as well, depending on where they are located. So there were these three categories. I'm just giving you the background in order to refresh your memory. And then what the Road Accident Fund did, and this may be while you were still in the region, Jacob Modise was the Chief Executive Officer of the RAF at the time. They then signed an MOU with Sunshine Hospital. Sunshine Hospital operates like Netcare. The doctors don't work for them. So basically, the MOU does two things in the main. One, the Sunshine Hospital administration will collect all the invoices from the doctors and anesthetists and all of those people, put them on one file together with its own invoice, and submit to the Road Accident Fund. So it then became an administrative agent for all of these treating specialists at Sunshine Hospital. The second thing that it was to do was to then provide the claims originators and other administrators of the RAF with an office from which to operate in order to service the clients, in order to service the claimants from. And then the third thing was they were to then provide them with a vehicle. But Sunshine Hospital said that vehicle was never used. The committee has a copy of the MOU, so that is where I am getting this from. And so the obligations we are talking about emanate from that MOU as well as subsequent obligations. I think the point is for the committee is that notwithstanding what the business model was, there is a pattern where 100% of the time Sunshine Hospital wins in court. But the RAF keeps contesting the things, and we need to understand why, because it doesn't appear to make sense. I think there is now over 4,000 judgments against the RAF. It's a staggering number. They run into hundreds of millions. The question is, okay, can you not settle this thing? Because each and every time you go there, you lose, right? And you spend money on lawyers and that kind of thing. It has to come to an end at some point. That's the background, Ms. Rambauli. So I'm not going to ask any questions because I understand you've been out of there for some time. Yes, but we agreed, honorable members, that we would take a break. Then come back to Honorable Nondenja and Honorable Skosana. Can we take a 10-minute break because we're not sharing facilities like we do in Parliament? Everybody's in their own home. Can we return at 11:05?
Thank you.
Thanks. Honorable members, welcome back. Mr. Rambauli, I'm hoping that you are back. Yes, okay, thank you. Yes, Honorable Scosa.
I'm sorry, and good morning to all my colleagues as well.
Yes.
Before we went for lunch, you've mentioned me, but I was not sure whether before you made your comments in closing, whether you recognize my hand. Thank you.
Yes, no, I did. So I was just saying that in the queue there's Honorable Non-Danger and then yourself. So I was just acknowledging that I've seen your hand, and so you'll come after Honorable Non-Danger.
Thank you.
Thank you, Honorable Scosan. Honorable Non-Danger, can I? Are you back with us so that I can start your clock?
Yes, Chair, I'm here.
Okay, thank you so much. Let me start the clock then. Over to you.
Thank you, Chairperson, and good morning, Chair. Good morning, Mrs. Rambauli, and morning, colleagues. Mrs. Rambauli, I would like to know whether the introduction of the new RAF 1 form was done while you were still with RAF.
Correct. Actual creation of the form.
I lost you a little bit there. I got the creation of the form. I'm not sure whether you say you were part of the creation of the form. Right. Okay. Mrs. Rambauli, in your observation, would you comfortably say the form brought some improvement to RAF claims and claimants, or has the form worsened the situation?
I would not be able to say that because it was at the cusp of when I was leaving. So I contributed towards the content of how the form must have information, and the actual implementation of the form happened when I had already gone.
I hear you. And when it comes to the decision that you approved, the security arrangement that it must be a monthly 150. I heard you saying that it was on a month-to-month basis. But when I look at this, there was a fixed amount that was approved by the board, which is a fringe benefit limit of 400. Wasn't the 150,000 per month now gonna be more than double the approved amount in your observation?
So yes, the security that was offered to the CEO was not a fringe benefit. It was a close protection evoked through the RAF policy protection.
In other words, what was approved? Was it approved by the board that his must be exceptional and be 150,000 per month, or was the 150,000 per month based on security expenditure where there are threats to any of the executive, or was it specifically for the CEO?
So the policy, as I understand it, is that if you evoke and there is a security risk, firstly, any other employees of RAF gets offered that. So it is not purely a CEO benefit. It is any employees that works for the road accident fund, as long as there is a threat. So that's the first thing. The second thing would be that the supply chain management will go out to go and try and source protection for any other person. And the last thing is that it has to meet the criteria, which is there must be a threat. So that's how the policy is designed. So what we have approved was not linked to the fringe benefit.
What you implemented, the 150,000 per month, was it approved by the board?
No, it wasn't approved by the board because the board didn't have to approve it.
Who authorized that, the 150,000 per month on security expenditure?
So the management committee, which is EXCO, discussed the security issues of the CEO and approved a close protection services on a month-to-month basis, not exceeding a period of 12 months. And that value came to 1.7. So yes, that was approved by EXCO.
Okay. Mrs. Rambauli, I think you said earlier on that you have no recollection of the letter that you issued, of the letters that you issued on the 2nd of November 2021, and you retracted the same letter on the 3rd. Is it possible that when you go back, you can go through that and let us have a response on that one? Because apparently the retraction didn't have any reasons, which raises the question whether the initial issuance of that letter was authorized on the 2nd. Is it possible that you can go and reflect on them and send us something, even if it's in writing, please?
I will certainly do. I will ask at that point we had a panel management unit. I will check and see the context around the circumstances of this issuing and retractance. So yes, so that's an action point on my side. I will make sure that it happens.
The same would apply to the approval by the executive of the 1.8 security expenditure. Please.
What would you need in that?
We would like to see the proof that was approved, the 1.8.
Okay, approval by EXCO.
EXCO, yes.
Happy with that?
Yes, thank you, Chair. I don't have any further questions on this matter. Thank you.
Thank you very much, Honorable Nadenja. So what we'll do, Honorable Nadenja, I'm going to ask the colleagues from Parliament to just go through the volume of documents that we got. But it is true that the matter never went back to the board. And I think Ms. Rambauli has said so. The only thing I wanted, so let me complete the first thought, which is that we'll just ask the colleagues to look through the documents we have to see if they can provide it to you. And secondly, if it's not available, we'll ask the RAF for the same, to reduce the burden on you, Ms. Rambauli, because you're no longer there. The only question I wanted to ask is who chaired the EXCO that decided on the security measures?
Hey, I don't know. I don't want to lie.
Who was chief executive at the time? I mean, doesn't the chief executive?
It would. I mean, I think Collins would have been the person who chairs EXCO, but I think because he was conflicted, he would have recused himself. So you will actually have to check if Mr. Rukwareni Patu was not the person who chaired it.
Okay. Are you aware that the procurement that EXCO approved was flagged as irregular by the Auditor General? That's how it ended up being on our desk now. Okay. That's why we're talking about it. We otherwise would have never. One? Your one.
Okay.
The 150,000 rand one.
Okay.
The 150,000 rand one. Yes, that one. That's why we're talking about it. Otherwise, we wouldn't be talking about it. So the only point I'm going to make is that there clearly appears to be a conflict between what the board understood was going to happen and what actually happened, because in addition, the former board chair, the immediate past one, also deposited a sworn statement in another matter, capping the security arrangements of this chief executive, saying that the only thing that carries is the board resolution at 480,000. In your defense, I have to say, because I have seen the minutes, there was that discussion that the EXCO will go. I saw the minutes. The EXCO should look at this within its within its realm. It's just that the entire scheme, notwithstanding, was found to be irregular by the AG. So we wouldn't be talking about it otherwise. Right. You get it, okay?
Yeah, I do. Right. I do.
Okay, you get it, okay. Honorable Skosana and then Honorable Bila. Honorable Skosana D.
Good morning, Chair, and to all the members, my co-colleagues, and Mrs. Rambauli. I just wanted to find out one. When have your last day in office was when?
August 2022.
August 2022. And in terms of security, what was the expenditure for you, or perhaps did you have any threats against you?
Me, Honorable Skosana, no.
Yes. Or you had no threats at all?
No, I was just too much of a regular to be experiencing any threat. So no, I've never had any threat. But what I can say that if we were to go into rough on the roads, there will be an assessment, and we'll only just have people that do due diligence and assess. And if we needed support, then there will be support. But otherwise, no, it was never had to have security. Thanks.
And how many companies have a retainer? How many companies had a retainer when you were still in charge? Like we had now, there's a company which is having a retainer of almost 100 million rand a month.
Yeah, I wouldn't know, Honorable Skosana. Like I said, I only was there for 18 months as the acting COO. And during my time, other than approving the CEO security for 12 months, by the way, I have not had any contract or dealings that required a huge security investment. So no.
So the accounting firm when you were still there, was it PwC?
PwC was procured for integrated claims management system, and it was also procured for the organizational structure reform.
And because why I'm asking that is that we picked up a lot of in some of us, not all of us. I mean, I was concerned that there was some payment to some companies as well, and you know, for me, which is a deviation of a serious nature, though. The presentation was that because of they want to get discounts and all that. And my question was, what if those companies get liquidated? Why should you pay them millions of rands in advance? What would be your take on that?
Like I said, it would have happened not during my time, but I think what you raise is a best practice. And the fund needed to follow best practice in terms of ensuring that they protect, the funds related to the road accident, because purely the fund's main purpose is that of paying claims. So I think your assertion in this regard makes sense. You ought to have put in mitigating plans and approvals that are sound.
You know the issue with me, that I understand, that the issue of accidents. Some of us, if one can calculate how much I've paid, and I've never had anything. Maybe we are still lucky in my family that, these insurances which we are paying millions of rands. And this accident, I never thought that this accident are so. I mean, there's multiple of accident daily because we are at risk. We are on the road, and there's a lot of challenges as a country. You even have people who are unlicensed to be on the road. But our biggest worry, as members of SCOPA, was that REF funds are paid as well to foreigners. One foreigner took almost R500 million. I'm not sure whether you are aware of that case.
I am Honorable Skosana. My personal view is that the Department of Transport, together with you, honorable members, have to assist, the fund in making sure that the legislation is changed. Because if it doesn't change, Honorable Skosana, we will find ourselves here perpetually discussing matters pertaining to RAF and why the fund is not capacitated really to run efficiently and effectively. So, indeed, there are claims that are foreigners, but it is because of the design of the Act that allows for that to happen. And until such time, the Act is changed, we shift the gear and move differently, it will continue happening.
I agree with you on that. And my last one would be, what is your take in terms of these, these claims? I understand that they say one of your, I'll say your former colleague, I'm not sure whether she was working with you then. She said to us that for anyone to fill the form, he's a chartered accountant, but she said to us she can't even fill that form of RAF. In your view, do you think people should only, I'm putting it deliberately, go through lawyers for them to be get paid, or should we? Reps should make sure that that application form is user friendly for even an ordinary person to avoid these exploitations, which we have seen. I've got a number of examples. There's a person in the Eastern Cape, one lawyer, who took almost 97.7% of the claimant's money to his own pocket, which is unethical. But I'm told the Legal Practice Council is dealing with the matter. But what I'm saying is, what I want to find out from you, don't you think people should be able to, I know the people say that is complicated because there's health reasons, health questionnaire in that form, but I'm saying, I think we can do better. I just want to find out from you that what's your take in terms of this application form, which we are told is as complicated that a chartered accountant cannot fill in that form.
Yeah, I agree. I think in principle, what you want to do is to create a balance between soliciting information that you want to be able to pay a claim and the ease at which people must be able to assist you in that. And perhaps maybe in its current form and nature, the RAF can do better to modify the form. And the other thing that I wanted to just highlight as we're now talking about the legislative nature is that it's difficult for the administrator in this term, the RAF, executives and the board, to change anything that will assist either the constituencies that they are serving or the claimant. You have to go through such a painful process to be able to change anything. So in principle, I agree, Honorable Skosana, the ease of business, doing business with RAF must be simplified, particularly for our claimants that are in the rural areas. But more importantly for me, it's also about understanding that you want to create a model that will bring in access. And access has got different permutations. And the one that is important and closest to me is that you shouldn't be having to travel the long distance for you to be able to be serviced. So a combination of ease of doing business, of accessibility, and making sure that those who are able to fill the form themselves can navigate the form and give you all the information, the right information for you to be able to make a decision. So it's a combination of those three. And if we can achieve that, I think it will be a win for all of us, Honorable Skosana.
On that, on the issue which I'll ask you about, the retainer, the Adams and Adams were part of that, am I right?
Adams, I would not know if there was a retainer for Adams and Adams. You will have to give me more specifics.
No, I was talking about, the big firms. Your Adams and Adams, Vexman, but it was Adams and Adams, if I remember well, that had a retainer, with the ref for almost 100 million rand a month.
I wouldn't know this. Perhaps maybe the CFO should be able to answer that question insofar as having the retainer and why was the retainer. You could find that they were trying to solve another issue that existed. So I would defer it to the CFO in understanding that she should be able to create context of why Adams and Adams were offered a 100 million retainer.
Let me put it to you. Even if it was not Adams and Adams, it's completely unethical. These monies, they make so much interest, giving any company for any other reason. There's no reasons which, in my view, that any company deserves to have a retainer of that amount, because, but as you said, maybe it's a question for the CEO or the CFO. Yeah.
Honorable Kosana, so without understanding the context around that, me and you may err on, applying our mind, but I'm saying perhaps if you get the context and understand why, and then question the logic behind that I think you should do. But as we stand right now, me and you don't understand the context of why. Adams and Adams would be given 100 million retainer. How much would you have been owing them? Because think about it, you would want to pay anyone because you owe them. So I would say let's have context to that.
No, for me, let me say this to you for free. There's no justification at all. They can give me 100 reasons. It won't make sense at all. 103 reasons of that. And the PMFA is very clear about these things. Because on the other hand, we will blame a ref for other issues that they are not following PMFA. But I've never seen anything which justify that. If you give it to a lawyer, he'll give you 100 reasons to pay that retainer. He'll give you the reasons. But I'm saying, irrespective of all those reasons, there's no way to justify a retainer. Because some people will say that nowadays, let me give you an example. Some companies don't want to do a business with government because of late payments. Now, they want upfront payment because of the failure of some departments of paying in time, the 30 days pay period. But for me, I'm still saying, it's not justifiable to pay anything upfront or to have a contract with someone which that money, irrespective of whether they've done the job, that money is not refundable. Whether they've done nothing for the whole month, you give them 100 million, or they've done a job which it's worth around 50 million, half of that. The other 50 will never get it back.
I hear you.
Thank you. Thank you, Jay.
Thank you very much, Honorable Skosana. Let me just ask you, are you picking up Adams and Adams from the documents that have been sent to us by the RAF? Because I've seen them in some of those documents.
Which document are you referring to?
No. Don't stress here. You'll soon understand why. I'm just talking to the member. Are you referring to the sheet that we were given with all the law firms and how much money?
Yes, Chair.
No,
as I said, for maybe I've made a mistake on the name, but if I remember well, I think it was Adams and Adams.
No, their name is there. Yeah, no, their name is there. So they are the attorneys that represent claimants.
Yes.
And they didn't do work for the road accident fund. So the amounts that you saw there were the cost of litigation, is the disbursements, the punitive costs, and so on, all of those kind of things. So I think you were in the ad hoc when we went through that sheet with the road accident fund to try and understand what's going on there. But you are correct, they got huge significant payments from the RAF. I think they ran into hundreds of millions, but they were representing claimants, not the RAF. Thanks, Honorable Skosan. Honorable Bila.
Thanks, Chair, and good morning to everyone. I hope I'm audible.
Yes, we can hear you clearly, Honorable Member.
You are honorable.
Yes. And my apology, Chairperson, for getting in and out of the meeting. Some of the discussions, I didn't hear them well because I was on another planet. So you will pardon me if I ask questions which have been already asked by other members. Rambauli, good morning.
Wonderful.
And because we were honorable watch out. I have 3 or 4 questions, Honorable Chair. The first one is regarding the security for CEO. Can you provide details on the governance processes that were followed in approving the security arrangements for the former CEO, including whether these arrangements were consistent with RAF's policies and board resolutions?
Honorable Bila, we did discuss the governance process that was followed, and as a result, I'm going to be sending, in fact, through the chair, they will want to see the approval of the security by EXCO, and any supporting documentation relating to this approval. So yes, it was discussed and it was agreed that you need to be finished with the information pertaining to the approval, which was done by EXCO.
Okay, thank you. I don't know whether it will also include any documentation that will justify the risk assessment which were conducted to support the decision to expand the close protection services for the former CEO.
I can ask the RAF to do that, certainly.
Okay. Were there any instances where you raised concerns on or sought guidance from the RAF board or other oversight bodies regarding the decision you were required to make as an acting COO? And if so, what was the outcome?
So prior to this decision being taken by the EXCO, it flew from the board discussions, and the minutes should be made available to this committee. I took it back to the board to tell them that we're not finding anyone. And the minutes of that board meeting reflect as such that we did indicate, and the board have minuted it, that they then agreed that a close protection policy must be evoked. And in that regard, the EXCO must be the one that makes a decision around this. Yes, so that was taken back to the board, and the information pertaining to the discussion will be reflected in the board minutes. That could also be made available for this committee, Honorable Bila.
Another question will be for the new integrated claims system. I just want to check if you are the one who envision and drive the strategy of the new integrated claims system.
I did indicate earlier on that I had a vision of implementing a claims management system for the road accident fund. It just so happened, Honorable Bila, that I left before that dream could be realized, and it actually left a gap in terms of SMEs around claims management. So yeah, but I never actually implemented it.
But yes, it was your vision.
It was my vision, yes, ma'am. I can say that. It was.
Not, I think you you traveled abroad with some team members. Is it correct?
Correct.
What were the lessons that you and the team that went abroad learned that you incorporated into the scope of ICMS?
So at a technical level, was that you actually need to design a fit-for-purpose claims management system that talks to solving the problems that you have. So what it means that your core system must be designed in a manner that it is flexible and it is intuitive. It is, it's agile in its approach, so that you don't create systems that when you want to make changes, it becomes difficult. So technically, we needed to find a very strong management claims system, which is the core, that needed to work. But more importantly, they told us that if you're going to put junk into the system, it's going to produce junk. So meaning, if you do not define your rule sets, if you don't have clarity of mind exactly what it is that you're wanting, it doesn't matter. You can bring the state-of-art system; it will still be a donkey. So that was the second thing. And therefore, it meant that in what we needed to do, we needed to make sure that we are not designing a system that is not fit for purpose. The third thing that I learned out of that is that in your design principle, simplicity is at the core. It must be claimant-centric. So when you design the system, you must put the member first in what you do, the claimant first in what you do. So those design principles, coupled with the fact that you want to delight your claimants, and especially around access, you want to make sure that you can talk to the people must be able to access this. People must be able to use the system in a manner that brings joy not only to the claimant but to the fund itself. So those are some of the lessons that we learned, and ultimately that the system itself must not be disconnected, meaning it must be an end-to-end, and where there are integrations, there has to be security measures put to make sure that it doesn't break your system. So those are some of the lessons that we have learned. And lastly, that it absolutely has to be cost-effective.
Thanks. In other words, you want to tell this committee that it was a fruitful trip.
Absolutely. I want to tell these members that had we not gone and learned what other people were doing, we would have orchestrated a very complex system. And in fact, Honorable Bila, when we came back, I then and I mean, honorable members can ask the board. I then came back and I wrote an operating business model that informed how the system must work. So yeah, it definitely was a worthwhile, both locally and international lessons that needed to be learned. Thanks.
Thank you. This question will only need yes or no. Ms. Rambauli, were you part of the BEC members who evaluated the ICMS tender bid?
BEC, yes.
Okay, no, it's fine. The last question, Honorable Chair. When Mr. Msiza was appointed, Ms. Rambauli, what role did you play? Because there was a mention that as COO, you wrote submission to motivate the increase of the CEO security fringe benefit.
That's not correct. So Mr. Msiza came through the office of the CEO. I had not known Mr. Msiza. I had not engaged Mr. Msiza. In fact, he came at the RAF and was reporting to the office of the CEO. And only after a while, he was then brought to me to say, security falls under your portfolio. So I would not have known the mechanics of how he ultimately landed into RAF. By the time he was appointed, I had already gone, and I did not approve the CEO's close protection or increase it. The approval was made by EXCO. Thank you.
Ms. Rambauli. Thank you, Chairperson. I'm done.
Thank you very much, Honorable Bila. So there are two members who want a second bite here, Honorable Atkinson and Honorable Skosana. I'm going to give them 5 minutes each. Honorable Atkinson, and then Ms. Rambauli and I will have a final back and forth, and then hopefully we'll be done. Honorable Atkinson.
Thanks very much, Chair. Can you hear me?
Yes, clearly. Yes, we can.
Great. All right, great. Okay. Chair, I do think it's quite important for us just to get full clarity on something which seems to be trotted out every now and then, and is, to the best of my knowledge, a little bit of fake news. And it's this thing about massive payouts. I do know that there was what they call the Switzerland case, where there was a claim for 500 million, and it basically almost broke the fund back in about 2012, 2013. But I do believe that mitigating factors have been...
2008, actually.
Well, the 2008, all the way back then. Okay.
I went to check.
Yeah, no, thank you. Yeah, because the former CEO trotted that out to us as well last year. But according to very reliable information, that has been mitigated, and that it actually cannot happen again, is that there has been a limit put on future claims, and that a similar thing can't exist. What I'd like us to do is actually just to confirm that, because the problem is that keeps on getting trotted out as a means to deny certain groups of people any attempt to be able to claim against the road accident fund. And I just think it's important for us not to be trotting out basically false news or false information if in fact it has been dealt with. As I said, I've heard from very reliable quarters that there is a cap in place now, and that that cannot be repeated. But I would like that to be confirmed, just so that this matter doesn't keep on getting repeated as fact, when in fact it is no longer something that the fund can do. And yeah, I just underline, this is a state insurance scheme. If people do want to claim amounts like that, then that has to be covered by private insurance. So, as I said, I believe that there's a cap in place, and if people want to claim above that, then they need to go to their private insurance to do that. Thanks very much.
Thanks, Honorable Atkinson. Honorable Skosana.
I understand that my colleagues is always defending this issue. It's a fact. It's not fake news. Whether it happens 20 years ago or 30 years ago, it don't change anything. It's a fact that that money was paid. The mitigation factor is another story. But I'm saying to you, Chair, we can't be hiding and defending things which the corporates and some individuals, or for that matter, a European individual. I'm going to just be frank about that. Because if it was somebody of another color It would have been something else. We won't sleep. We'll be told and reminded daily about that. Now, I want to say clearly here that I've got nothing against anybody. You know, I just want us to be honest and frank and be a scoper, which we're supposed to hold everyone responsible and accountable. To my last two questions to you, which I've forgotten to ask you. Have you ever worked for Discovery? Hello?
Ms. Rambauli, you can answer. You can answer if you worked for Discovery before.
Yes, I have. You can hear me.
No, we can now.
I can hear you now.
Just answer again. Yes,
I have worked for Discovery.
And who writes the directive, the part medical directive?
It's me.
Why?
We have had a discussion about the past medical expenses and whether any other healthcare insurer is entitled to claim or not. And that's the reason why I'm told that that case is still going on. So context around it was around that. Honorable Chair, can you hear me?
Honorable Skosana, are you there?
Yes. So I wanted to say that yes, the case is still going on. I'm aware of that. That the case is still going on. In fact, we are in trouble because of that. Are you aware that we are in trouble because of that?
I don't know.
Yeah, we are in trouble because of that. Remember that the issue that if medical aid has paid people and REF must still pay the same people, I don't think it's ethical. I don't think it's ethical. For me, it's double payment. What's your take on that?
I don't know if I'm allowed to answer this, considering that this matter is under court, Honorable Chair. I don't want me in my personal capacity to be overstepping my boundaries, but the context to
let me. Oh, sorry. Now I was going to say perhaps I should guide you in this way. So Honorable Skosana is asking you for your. Honorable Skosana, please mute.
Yes. Let me mute.
Oh, there's somebody behind you. So
yeah,
Honorable Skosana is asking you for your opinion on whether you think, medical, it will have no bearing on the case. I don't think it will, unless you feel there is a reason why it will have a bearing on the case, in which case you can then say, but is asking you for your opinion. You either have an opinion or you don't have one, but there is nothing wrong with a member asking a witness to express an opinion on something.
Perhaps
so you're not being asked in your capacity as chief operating officer at the time. Am I correct, Honorable Skosan? So Honorable Skosan wants to have your opinion on the matter.
I think in the context of a situation where you have to put a person where they were before an accident, if the person didn't suffer any financial loss personally in their own capacity, I believe that you shouldn't. That's my opinion, Honorable Skosana.
Okay, Chair, let me listen. I'll come back. Thank you.
Oh, you listen on the radio. Okay, Mr. Rambauli, I just want to canvass a couple of matters with you, and then hopefully we can let you go. It's been a long morning, so I just want us to talk about a couple of things. I think I'll go back to a combination of things. Because part of what we're doing is seeing what went wrong. And when you talk about what went wrong, it's not to say someone deliberately made things go wrong. It happens in the course of doing work that decisions have consequences, and sometimes things work really well and sometimes they just don't. So it's always important to understand. So I am going to put a scenario to you in order to shorten this. So my understanding of the totality of the evidence that we've received so far, and then put a proposition to you. I think that will be quicker instead of asking you 15 questions. And that is that one of the things that we all want to do is to reduce the amount of money the Road Accident Fund pays to lawyers. In other words, shorten the process, simplify it, make it as it's administratively intense on its own, but try and reduce the extent to which you add another burden of administration on the RAF. In the end, it will be simpler for the claimants, and then the right payment can be made to the claimant without having to go to court, such that if matters end up in court, it's really a smaller number of instances. Now, legislation has a part to play in that, which is Parliament and the Ministry's job, but also administrative process. So that is the outcome that the committee is hoping to get to in its recommendation. I believe that there were several developments that were unhelpful in the end. Development number one was the withdrawal of claims originators, in the sense that absent of someone from the Road Accident Fund that you can rely on to guide you, you then have to go to a lawyer, which introduces lawyers way too early in the game, in my view. All right, so that's proposition number one that I'd like you to note and comment on. Proposition number two is that the decision to abruptly cancel the panel of attorneys caused two problems. Problem number one, there were a lot of matters that were not defended in court, summons couldn't be answered, etc., etc., and it was taking long to hire people who were then going to replace them. Number two, the medical experts who were tied to the lawyers also then were disconnected, and they were tied to the lawyers who were told that they were on the RAF panel, but they were being briefed by the lawyers and so on. So there's something in the administration there that did not appear to work properly. But you have these two big disconnections, right? And these two big disconnections, in my view, cause a further escalation in court matters. At a time when the Road Accident Fund does not actually have a panel of attorneys, and it also does not have state attorneys yet. And the claims administration process is left to handle the fallout, right? That's conclusion number two, and I'd like you to comment on it specifically. So that would be number two. Number three is the Section 189 process, right? And I don't know if it happened after you started. It's fine. You can just say to me at the time, so look, I wasn't there, in which case just skip it, right? There's a Section 189 process it also creates movement and uncertainty in the organization at a time when it's dealing with these massive challenges that we've spoken about, right? Number 4, which we can have a bit of a back and forth about, is the rough one form, the new one. Here is my understanding from what several people have said, and I'll talk about 2 sides of it, before the new rough one form, after the new rough one form. And I'm not invalidating any of the problems the new rough one form was trying to solve, okay? The colleagues have explained that in order for the claim to go faster, you need all the information when the thing gets in. And then it will go faster because we've got all the documents we need. That logic makes sense to me. So I'm not fighting with the logic. I am now grappling with the impact on claimants and so on, because here's the journey. I am in Malamulele, as Honorable Pila had asked the other day. I used to have somebody who could help me. I don't have them anymore. The only person I can go to is an attorney. Now, a cost process begins already there, right? Number 2, you've got all of these claims that are in the system. Some must go to court, etc., etc. There is nobody to attend to these matters, which means they take longer than they otherwise would have taken because the situation is a mess. Some files are not available, etc., etc. Then there is a Section 189 process, which introduces uncertainty and movement of people within the organization problem. There are suspensions, etc. Rough one form. It requires that you actually wait for MMI before you can lodge. You have to wait because you cannot produce the reports needed for the RAF to quantify, because you need MMI, don't you? You need MMI to kick off the other evaluations, which means we are asking the people to wait. Now remember, I will go back to the claims originators and their ability to work through the RAF system. Now I have to find all the medical experts myself as a claimant, assuming I don't want to work with a lawyer. I must find all the medical experts myself. I must pay for the medical legal reports, etc., etc. And then I will be deemed to be compliant for me to get a claim number or a link number, and then the process can go. Over and above waiting for a year for MMI. In that year, depending on my condition, I need all manner of things. Secondly, I really may have been a tractor driver in the village and I really need the assistance and nothing can happen, right? So I'm really stuck. This causes people, those who can find a lawyer, to go to an attorney whose firm is big enough and rich enough to go and pay for these medical legal reports because I don't have the money. They will pay for them and then wait years until the claim is settled, and then they get a big sum of money out of the legal process. If you are a small black law firm, you actually also, the partner himself, the managing partner, does not even have money for themselves. So they actually can't afford to pay for these medical legal reports, actually, on their own balance sheet or their own account, and then get paid later, right? So this is the scenario that is unfolding. In the end, to go back to Honorable Beasley in the morning when we started, it seems to me, if I can go to Gertnel attorneys or Dibrolio, this is what gives them the exclusive market because they've got deep pockets. They can pay for these things and only get paid in 4 years' time. If I go to Mfingwana Incorporated in Flagstaff, Mfingwana is struggling himself, so can't help me much. My claim prescribes all manner of things, and actually I'm left out in the cold. Finally, if I was in a hit and run and my claim is refused, the 2 years expires while I am scrambling around trying to find somebody to help me. And then when I finally submit the claim, I will be told your claim is prescribed if it was a hit and run. If it was 3 years, it was something else, I will have been out of the system as well, which means I don't get the help. That creates a market for lawyers of simply interrupting the prescription, where all you need to do is to send a letter of demand or go to court and that kind of thing, just to get the claim admitted now, right? And then you fight the second part, which brings up the legal costs. So let me leave it there. You were taking notes. This is the impression that is forming in my mind, and I'd like you to comment on it. Go down each of the points.
Down each, yeah.
Yes,
I think before I do that, because you although you have mentioned pockets of issues, I want to give you an overarching statement.
Yeah, that's fine. You can do that. You can do that.
Because it's about leadership, and fundamentally, when you are driving change, right? When you're an effective leader, you have to fully orchestrate that change. Because the absence of that, if you don't orchestrate your change, you will find that you are all over the show. So I just want to craft it and say, while I understand all these things that you have mentioned may just be a symptom of a bigger problem, and the bigger problem could just be that fundamentally, the law of life doesn't allow vacuum. If you don't do what you're supposed to do, it will fall apart. So that's the first one. You must drive change. It must be intentional. It must be orchestrated. It must be aligned to strategy. And the pace must be right. So if you are doing so many things at the same time, you are going to drop the ball. I don't care whether you are Einstein or you think you are bright. You are going to fail. So when you are an esteemed executive, you know that you need to change things, but you also are careful about the pace at which you are introducing these changes, because if they are not properly planned, you are going to drop the ball. And if they are dropping at a pace where, things are just happening, you are actually also just setting yourself for failure. Secondly, I want to also say that has to be supported by systems and your people. I call it care for the carers. Honorable Chairperson, if I work for you and you don't look after me and you expect me to look after your people, it ain't gonna happen. So learn to understand the system that exists and the people that you have been bestowed to be the carer of have to care for your claimants, and therefore you have to orchestrate a strategy that cares for the people that care. And ultimately, you want to make sure that it delivers a sustainable and impactful product. So that's what, when you are a leader, what makes you awake at night. You want to make sure that whatever that you're doing, it's it fits into that structure. So for me, my sense is that there were a lot of things that were happening, and it could be that we were moving way too fast, and many balls were dropped on the floor and were left, and that's just my opinion. And secondly, that in the process of moving fast, you were moving there, but you have left your people behind. And any leader will tell you that if you are moving alone, one day you look back and you'll find that it is just yourself and you. So that's my overarching. statement. I am going to connect number 1, which is claims origination, and the RAF form, and say the law doesn't allow vacuum. We took people away, and not only just to complete this form, but to be the people that when you needed a friend, when you needed just to ask, these people were in hospital, you know, they were stationed there. You could go and ask. They can explain things for you. And they closed a knowledge gap that existed. And they closed a gap of brand RAF. So RAF just disappeared in the society, and that could potentially have created anxiety leading to what you refer as going to the attorneys. I don't know, but my thinking is that if you don't see RAF in the community that you are residing, in the areas where you are, the next logical thing will definitely be that you will go and ask for a lawyer. I'm tying it to RAF Form 1 because the claims originators' primary role was exactly that: assist somebody who comes in, and they would tell them, ma'am, this is the form that I need to fill. You will require this and this and this and this. If you go to police station, they will give you this. If you go and certify your ID, do this, come back to me, and I will assist you to complete this. Once I've completed it, they will stamp it and they will give you your information, and they will say, in a month or so, if you don't hear anything, please come back. If you've got a form of a phone, you will receive some form of notification that informs you that your claims have been registered. So we took away that. I take your point when you say you are linking the claims originator and the RAF form to the legal process, to say you remove any support that your community have, there is no one to help you, where else can you go? Logically, perhaps maybe yes, you will end up going to the lawyers for assistance. But I must also hasten to inform you that the RAF form, you know, its mechanic was never meant to create an administrative burden to the claimant. It's just that, you know, there were just many moving parts that created that vacuum, and ultimately leading to unintended consequences that the RAF may find itself. On the issue of the medical legal aspect, I can't add any further information. Your scripts narration makes sense. Absolutely. They are the engine of your medical reports, and if they fail, it means that you are not able to quantify, you are not able to produce, and therefore the delays in the claims processing space. Hit and run, I agree, 2 years, you are left with not much choice, but absolutely to do what you need to do to make sure that your claim doesn't prescribe. And with that, I am left with 2 aspects. And I don't know which one I should handle first, whether I should handle section 189 or I should handle the decision to cancel the panel. Maybe let me start with the decision to cancel panel. I wasn't there, but what was clear, Honorable Chair, was that there was clarity in mind that regardless of whether it is panel or it is any other person, the RAF needed to be represented. In its current nature and form, the RAF could not have sensibly have decided not to have representation. So it then takes me to, if that's the case, and if that's the thinking that you contend that you must have legal representation, what is the form and shape? And how soon do you do that? And I think it is in the implementation, honorable members and chair, that I think things just didn't go right. I don't know whether there was a plan. And if there was a plan, why things didn't go? Because honestly, doing away with panel had RAF, not only administratively, but with the default judgment, which the amount was not justifiable. The quantum, when I say amount, I'm talking about the quantum. So I wouldn't be surprised that the claim cost per member has gone up. I mean, I don't know if they have done that or not, but
Yeah, in fact,
in the actuarial space, what we normally do is we don't measure so much about volume. We measure the cost per claim. Has it gone up? Has it gone down?
Let me give you a sense. So I think when you were there, and I'm not attributing this to you, the Road Accident Fund finalized about 253,000 claims with between 41 and 43 billion. That same amount of money now covers just over 70,000. Same amount of money covers over 70,000. The legal costs have gone up significantly per claim, and the value of the claim has gone up by 70%. The value per claim, which says to me, if you are not there to contest an inflated claim, you are going to have a problem. If you don't have your actuarial reports and your medical legal reports and so on, you are going to have a problem. So what we've ended up with now is the Road Accident Fund, if it were to improve its administration process, problem is the gap, the financial gap will be bigger because your cost metrics per claim have just gone completely the wrong way. So I thought I should just tell you that, which is one of the reasons we decided to have this inquiry, because obviously that's a situation that must be arrested. You want the Road Accident Fund to go back to a situation where it's spending the right amount of money per claim. The lawyers are not getting too much and so on, and most of it goes to the claimants.
Yeah. So yeah, definitely. So that default would have contributed to an increase of cost per claim, and the increase in cost per claim, what it does by design is that it renders the fund unsustainable. You cannot have a situation where you have got runaway cost, and some of us who come from that environment, we know that what you chase is to make sure that the right claimant get paid appropriate amount of quantum, and if you don't do that, then you're not managing your risk, and that's beside the point that you have got fraud risk that comes along with that, but also the fact that you are just allowing plaintiff to decide. It can be that plaintiff lawyers are allowed to just be the one that dictate, purely because the fund doesn't have enough team to dispute and represent itself when it's warranted. Medical aspects, of course, we have. I mean, I spent a lot of time talking about medical expense, which contributes towards assessment in ultimately coming with a quantum, and all of this, and you can see, I mean, it's happening in such a short space of time. Everyone else is running around, and I think somebody needed to just stop and reflect and understand, okay, this is what we're doing right now. What is it? What are the levers that I need to pull now to correct where we're not moving fast? But more importantly, what do we do next? And perhaps maybe nothing in the next 2 years, because actually you need to make sure that all these initiatives that we have, you tie them and make sure that at least there's enough time for them to demonstrate that they are working. You cannot just, this year you're doing this, next year, hey, no. Doesn't work like that. Not anywhere, even in the corporate. Doesn't work like that. You have got an orchestrated list of planned activities and you give them time and then you go back. It's a yin and yang, yin and yang. So that's where I am. Section 189, I was in that poll, Honorable Chairperson. I was in the Section 189 process. And my contract ended. It was never extended because my job became redundant as a regional general manager. Never got any extension. So I was then told on the eve of my contract that thank you, but no thank you. Go. So when I went, that's where we are today. Thank you.
No, thank you. So can I just ask 2 more questions? The first one is, would you attend board meetings around the time of this change, the new strategy, these kind of decisions and so on?
I attended board in from 2020 until 2022. So that 18 months I would attend, yes.
Would the board ask, hang on, can you coordinate all of these things properly? Can we see a plan that brings all the things together? Can we see how long things are going to take, how they fit together and so on, and come back and present that to us with a resourcing plan and so on? That's what we expect a board to do. The reason I'm asking is because perhaps it's not captured in the minutes. We've been given board minutes for lots of meetings. I don't see that conversation, and I need to ask you, as somebody who would attend, whether the board, the different boards, would ask for a proper implementation plan of all of these things and resourcing taken together, because this is a huge organizational transformation. It can't happen haphazardly.
Chair, there were some dissenting voice. There were some board members who asked questions. Yes, I would say that.
But so when you're saying dissenting, then their voices would not carry in the resolution because there were too few.
Yeah, or ultimately end up leaving. I mean, I know one actuary who ended up leaving. So yeah. But to note it that they went means that it was a homogeneous group. It has always not been a homogeneous group. There were people who had dissenting voice. Yeah.
In your view, what created that dynamic? I mean, in your observation, you are not a member of the board. You speak on your own issues on the agenda, I'm assuming. Why would that be? And I'm going to ask you, and this is for our recommendations. I'm going to ask you as carefully as you can, because we also don't want to impugn people. So let me place my proposal on the table, and then you can comment on it. I think it makes it easier. I get a sense that the board members did not have a proper understanding of the RAF. They didn't appear to be the RAF and its operations, firstly. So let me say the RAF and its operations, it did not appear to have enough practice-related experts. In other words, the RAF performs an insurance function in the main. right? In the sense that loss of future income is insurance. Future medical expenses, maybe you can say it's a social insurance, but general damages, you insure that sort of thing, damages and so on. So what I'm trying to say is you need different experts. You need an actuary, you need an auditor, you need somebody who's perhaps an industrial engineer to work to understand process and planning and project management and ask the right questions and so on. So what the impression I get when I read the minutes of the board meetings, there are questions that should have been asked that are simply never asked, which begs the question for me, but how was this board functioning? Because there are some logical questions here that never get that's where my question is coming from. So I'm not asking you to criticize individuals. Yeah.
No, and I will not do that, Honorable Chair. I think I would just give you a recommendation without venturing into.
Sure, yeah, that's also welcome.
So my recommendation, insofar as the board composition, right, is that. You see, if you are going to have a board that you want to be astute, the competency must be there. So where a mix of technical skill required to be able to administer this, but the experience in governance. And I'll tell you, a lot of time, people fail not because they are not competent, but they lack understanding of oversight and really sometimes just crafting a question to get the answers that are not visible. So, and when you are a well-established governance person, you are quickly able to see, between the lines. So you need technical competency, you need people with governance and oversight experience, and you need diversity. I tell you, diversity works a lot. It doesn't matter in what form or shape, but it creates an environment that you are here to fulfill your fiduciary responsibility. So it keeps people in mind that, I need to bring my A game. And lastly, you have to strike a good relationship between the chair and the executives, right? And I say a good balance because the minute it becomes way too easy and people think that they will walk all over you, but you also don't want to be productive and be asking the CEO everything. So it must be well balanced. And the CEO needs to know that, I account to the board. And what does that mean? Similarly, the board needs to know that it needs to give the CEO room and space to be able to do what he has to do. And when he doesn't, that's the key. When he doesn't, you don't faff around. You hold him to account. You ask pertinent questions. And everyone else accounts. And it's not just the chairperson, it's the entire board. So if you can't hold anyone accountable, then you are not a governance structure. That's my comment. Thank you.
All right. Thank you very much, Ms. Rambauli. Honorable members, I don't know if any of you have got any further questions. I don't see hands.
Thank you so much.
I don't want to prolong this any more than we should. Okay, I don't see hands. It looks like you were hoping that no hands are going to pop up.
Exactly. Otherwise, Honorable Skosana will come.
No. I understand. It's been you're on the floor the whole time. We've got the benefit of sitting and listening to you speak. So I just want to thank you for coming through. So what we'll do is we'll we will ask for some of the documents that the members wanted because you're no longer at the RAF. We may ask you to provide us with further assistance. I think in all probability it would be in writing rather than being an appearance like this. And then when the report has been drafted, we will we'll give you the opportunity to comment on anything that mentions you or that pertains to you. I don't want to say that implicates you because it sounds bad, but on anything that has got an implication on your testimony. We'll give you an opportunity to then read what we've drafted, send it back to us within an allocated time so that we can then take all of those comments into account and then finalize the report and table it before Parliament, and the Speaker will transmit it on to the Minister. And then the recommendations can be implemented. So that's the process that we're going to undertake. I see Honorable Atkinson has thought of something. No, the Honorable Atkinson is usually short, so don't worry. Honorable Atkinson.
Yeah, no, thanks very much, Chair. Just maybe another thing that Ms. Rambauli can add to the report is that issue around caps on claims. So I do think it's an issue that needs to be clarified. And I do think it's very important for us to know exactly what the caps are on claims that members of the public can make against the fund. Thanks very much. Thank you.
Awesome. Will do. Thank you.
No, thank you very much. So I want to thank you, Ms. Rambauli, for availing yourself today, and we wish you a wonderful rest of the day. And Ms. Ibrahim will be in touch with you as and when needed. But like I said, it would be for written submissions rather than an appearance like this. I also want to, I think we can release you. There's an aspect that we have to deal with the members, our own business. So let me thank you and release you because I nearly forgot. So thank you very much. You can log off. We can then have a short discussion as the members about something else.
So, Mike, let me take this opportunity through you, Chair, to thank the committee for allowing me to participate and make a contribution. And like you said, the idea really is about making sure that all of us contribute towards a well-functioning road accident fund. And thank you. Bye-bye.
Thank you, sis. Thank you so much. Honorable members, may I then update the committee on the issue of the summons and where we are. So the sheriff has sent to the legal team a return of service note. I hope I'm saying it correctly. They've attempted to locate Mr. Litswalo at various addresses. They have not been able to find him. The one address which he had given to us was not inhabited. And then the other address, there appears to be people living there, but nobody is answering, and they can't force their way in, obviously. We have then been advised that we can also reissue electronically, which means it will be sent to every channel that we know that he can access. This is WhatsApp, this is a notification on SMS, this is email, so everything that you can, including a redacted version that is put up on Parliament's digital channels. In other words, you redact the personal information that would amount to revealing where he stays or phone numbers, or, those kind of things. So no personal information, but enough information for him to know that he's required in Parliament next week, Tuesday. He does not have to tell us that he will come, I found out. So on Tuesday, we must still set aside the day in case he walks through the door and says, I am here, please talk to me. If, for instance, we schedule something else, he may then say, well, I was going to come, but then you guys decided to do something else I saw on the internet, so I could see that I can't come. We must then, at our meeting on Tuesday, after waiting a reasonable time for him to present himself, then make a decision about what then to do. Obviously, we will then need to adjourn, but we need to then have a discussion about next steps. I am just going to make certain that I am not misrepresenting anything and ask Ms. Ibrahim to just comment on what I've just said. I don't see a name on my screen.
Yeah, Chair.
So just please correct me if I've missed anything in what I've said.
No, Chair, you're absolutely correct. After the summons was issued, we asked the sheriff to serve at the address that Mr. Litswalo had used on correspondence to us. So those various letters that were going back and forth that members are aware about. The sheriff then reported that, as you indicated, that address seems to be abandoned. That was also the address that was provided to us by the RAF. At the same time, we had also sent it to him via his email, and SMSs were sent by the Secretariat. They also tried to make telephonic contact with him. We then tried a second address, which was provided to us by the RAF. That address appears to be occupied, but after several attempts by the sheriff, there was no one to serve the summons on. So whilst it could be served on another adult present at the address, there was nobody that was answering when the sheriff attempted to serve. What we've now done, Chair, is to ask the Secretary to Parliament to reissue that summons to allow us to serve, as you indicated, via SMS, email, to publish it on the parliamentary website and so on. And that permission was granted. In the meantime, we've also continued to try to make phone calls. A letter was sent immediately after the initial summons was issued to let Mr. Litswalo know that the sheriff would be serving the summons on him. So from my side, Chair, I'm fairly confident that Mr. Litswalo is well aware of the fact that he is expected to be in Parliament on Tuesday, notwithstanding that the summons has not been served on him personally. Merely because it has already been in the public domain, and I would expect that he would be following proceedings, considering he is the erstwhile CEO, and he was well aware of the fact when he was CEO that the committee had commenced with these proceedings. The terms of reference also included his name as a witness, Chair. Thank you.
All right, thank you very much, Ms. Ibrahim. So that is where we are, honorable members. I just want to ask if any member has any questions, but that's the state of affairs right now. Honorable Beasley.
Thank you, Chair, and thanks, Mr. Abrahams. Just to, where will it be? You mentioned on the Parliament website. No, where particularly in the Parliament website would it be? Thank you.
Oh, I may not know those specific details now. Ms. Ibrahim, do you know?
Yes, Chairperson, through you, there is a landing page on the Parliament website specifically for this inquiry. So if you open the parliamentary website, you'll see that there's a banner on the top that moves and shows you current business of Parliament. And that banner has a specific landing page for our inquiry, as well as the other inquiry that's taking place. So we will put it up there, but I've also asked the media unit to ensure that they post something on our other social media platforms like Facebook, Twitter, and Instagram, whatever it is that they may be using. And Chair, in addition to that, we've also asked the sheriff in terms of the new authorization that we've received to put a copy of the summons on the door of the residence, even though a note had been left. Thank you.
All right. Thank you very much, Ms. Ibrahim. So, colleagues, that is where we are. I will be working with the Secretariat team this afternoon to nonetheless produce a briefing document for next week. As you've seen, we just do one now for the entire week. We also have board members who, and I must say, we were conscious enough to give everyone an opportunity to know around which time we are going to need them. So we gave them a list of dates. For example, with board members, we made clear we will need them more towards the end of the process, or we will need you in November, so that they could make their arrangements. And then as our program crystallized, we then specified the dates. We now have board members who are giving reasons why they can't appear on a particular day next week. They want to appear on such and such a day, and so on. For instance, there is a board member that wants to now appear on instead of Wednesday and Thursday, but Thursday and Friday. So I note you, Honorable Skosana. So, and the reason some of them give are things that affect all of us. So one board member has said, I've got my child school thing. I think members themselves miss a lot of things at school for their children on a regular basis. I think to ask for a person to indulge us for one day is not reason enough to extend the inquiry by another week so that somebody can go to their school thing. So my view is that we try and accommodate those members, but we don't deviate from our program. And therefore, for the members that wanted to come on Friday as well, that actually we say to them they must come on Thursday. We will then sit until the evening until we are done with them. So instead of coming on Friday, because it then does affect members' travel and so on, because we can't have a meeting that is in person and then it ends up being virtual with travel in between. Also, Friday had not been, intended for this purpose anyway. So that's basically what I'm suggesting. So Thursday would be an extended day, but then we would not have a sitting on Friday. I saw Honorable Skosana's hand.
Thank you, Chair. I just want to find out when it's our due date that we have to end this inquiry.
So Honorable Skosana, our intention was to end this inquiry in the first week of December, and then spend the rest of the festive season and so on writing the report so that it can then be put in the program for the first term of next year. What has happened is that during the course of the hearings, we have realized that there are other people that we did not envisage we would need, which I think is a same experience you are having in the ad hoc, where you are realizing you need to call certain people. The idea, therefore, is that we finish with all the core witnesses by next week. The only thing we would have next year would be the current board as well as the minister and deputy minister, and then we would be done, which means we might complete the business within 2 days, basically Tuesday and Wednesday, and then we are done.
Oh, no, now I understand. In fact, you made reference to the ad hoc committee because some people are threatening us to take us to court. Some are threatening some witness lives and that, Yeah. So anything is possible. I mean, as you said, one board member says it's got a children issue, and I don't want to go there, because if we can start that one, someone will say my grandchildren is sick, or my niece, or my and that. So we won't end. I mean, this thing won't come to an end. But be that as it may, we have to be reasonable as well, as we have said, and accommodate anyone, to get the truth to this matter, and finally.
Yes, no, absolutely.
Ending, but thank you, and it's very unfortunate that it coincided with coincided with this ad hoc committee. I wish, Chair, I were part of.
No. We appreciate it when you make time, though, like today. No,
Thank
we really do. So, honorable members, that is where we are. Just to update. So on Tuesday we will convene, but it might end up being a short session. But we have to make the allocation as intended. Otherwise, we will then be speaking against our own summons, which said we will provide him an opportunity to speak to us on Tuesday for hours. All right, honorable members, in the absence of further questions, thank you very much. Please have a good afternoon and weekend, and then we shall convene on Tuesday. Thank you so much.
Thank you, Chairperson.
Thank you.
Thank you, Chair and colleagues.
Thanks, Chair.
Thank you, Chair.
Recording stopped.